2008 by NAC in its third cycle. I'm sorry for that. Now it is time to introduce esteemed expert who will enlighten us today with his invaluable insight. Advocate Mr. Keshav Thakur. Sir is a distinguished legal professional with over 30 years of experience, practicing since 1994 at the Supreme Court of India. He is currently empaneled as legal counsel for esteemed organizations such as Punjab National Bank, Central Warehousing Corporation, Oil and Natural Gas Corporation, Food Corporation of India, Repco Bank and Exim Bank. He holds the prestigious position of Panel A Counsel at the Supreme Court. Mr. Keshav Thakur possesses extensive expertise in handling a diverse area of legal matters, including civil appeals, revision, civil writs, and high-profile cases under the Indian Penal Code and special acts. He has successfully represented clients in TADA cases in Jammu and Kashmir, showcasing his proficiency in handling sensitive and complex legal disputes. Additionally, he has carved a niche in NDPS matters where his strategic advocacy has resulted in a securing a bail for his clients in challenging cases. Throughout his illustration career, Mr. Thakur has represented the central government, including entities such as Indian Railways and the Central Bureau of Investigation for over a decade, gaining unparalleled insight into the governmental litigation and public sector disputes. To express our appreciation for Mr. Thakur's invaluable presence, we now present a green welcome, a small yet meaningful gesture to celebrate our commitment to sustainable growth. Now, without further ado, I invite Mr. Keshav Thakur to take the stage and share his invaluable insights with us. Yes.
That's basically short my 2 minutes to introduce myself, because I must implement that you have researched very well as far my file is concerned. I don't know how you got this thing regarding Tata cases. This was I remember the initial days of my career when I started my journey in the legal profession after doing law at Campus Law Center. I'll be very short in this. I joined Mr. J. Milani, who was that time the top criminal lawyer, and that time he was doing Sanjay Dutt's case. Now, Sanjay Dutt, I was just telling you, ma'am, in fact, he was from Shimla. So I told her I was also studying in Lawrence School, Sna, and Sanjay Dutt was my senior in my school. So Sanjay Dutt basically wanted me to help him because he trusted me, being from the same school. And as such, that is how he requested Mr. Dalton Thakur, that you must have heard of the famous actor. He said, I want Keshav to be involved in this Tata matters. So that's what we were doing in the Supreme Court. So that time I just stepped into the profession. So that was my first case. And so that is why when she thought about she started talking about Tata, took me way back, 30 years back when I started my legal profession in this field. Anyway, before I begin, I'm so sorry. I would first of all I'd like to thank Mr. Vikas Nath, who is the director, and of course Mr. Aruna General, who is the vice chairman, and the faculty members for inviting me here today in your prestigious institution. And of course, what I'm going to basically speak on, of course, is digital contract and all. And I am sure you'll be able to make a best of it. But one thing is there, like I was under the impression that your first year had already, it's on the verge of ending or it had already started. But I was just told that you're basically beginners. You also like, I joined a new profession, so I was also started with that when I was a fresher and exposing myself to Supreme Court. And similarly, you people also are absolutely new into this field, just joined the legal fraternity. And of course, I have to be very careful in explaining to what basically it has to be in a typical layman language. So I will not go into the deeper, diverge into legal language or the sections or provisions. But of course, broadly, I will just explain it to you. So basically, in today's lecture, I'll be basically talking about the digital contracts and its validity and everything what, of course, to our topic, you are well aware of this. And then I'll just explain the relevant provision of law. Because this is a new act. This came about in 2023. So why this came, what was the need for, what was the requirement for this act, and why in today's change in economics and global diversity as far as technology is concerned, why there was this requirement. Then number two, then I'll just broadly tell you what this act is about. Because as a young lawyer, as the budding lawyers, you must know that what all is this law about. The idea is not for you to learn and understand this thing. The idea is basically so that you can reach out to the other world. Because don't forget that you are the budding lawyers, you are the next generation lawyers who have to introduce the illiterate who are not aware of what law is. So that is the idea. You have to keep this in mind. One thing is very clear in this profession, money should not be the criteria of everything. You should not chase money. If your intellectual is clear, if you are clear in the concept of law, if the judges recognize you, money will follow you. So keep this, this is one profession where you should not ask anybody, okay, how much I'm going to work in your law firm, I'm going to work with you, sir, how much will you pay me? No, that should not be the criteria. The criteria, you should be hungry for knowledge. If you grasp this knowledge as early as possible, it is not for you to make your own profile, but you can reach out to the people at world at large. So what I'm trying to say is that you being the one, you have to move forward in this world. Because India is such a country, we have a lot of legal loopholes. One thing is there. Of course, people like me at this profession, at this stage, we know how to take on a loophole from any legal provision. But the idea is how to use this loophole positively for the society, for the public at large, in public interest, for the country. So keep that in mind. Like now, the reason I'm once again going back to the data, the thing is that once after Mr. Jethmalani taught me the loophole of data, I wanted to experiment myself, and I went back to J&K, and because that time J&K was the one that they were at large. And I had these 4 cases. Once I came to know he's recommended of Mr. Jethmalani. So I did this because he never would go out of Delhi. He would go to Bombay, Metropolitan study, but J&K would never go. So he said, why don't you do this case? So I just took in the matter that, alright, it's of public interest, I basically wanted to assess myself. So I just wanted to assess myself, कि मैंने जो सीखा है, मतलब मैं कर पाऊँगा या नहीं? So just for this sake assessment, and believe me, I did not take any money. And you won't believe it, I got the positive results, and those people, the Tata people who I knew had done the criminal activity, however, then against they were the ones who basically terrorists against the country, and they were acquitted. So that, when they were coming out, then that's the time when my seniors and my fraternity members, my family members will say, look, what you have done, do you think it's the right thing? And that was the first and the last case of Tatas, and thereafter I stopped taking Tatas because these are the ones who basically are fighting the country, against the country, fighting the country, killing the innocent person, and I as a lawyer, I am protecting them, I am getting them out of jail. So that made me conscious that I could sleep for next 3-4 years or something. So that was the time I thought that, no, this is the finish, this is the end, I will not take it. After that, you won't believe, after getting results, there was this floodgate in the data cases and they say, yeah, sir, तो इनको quit करा दिया तो ये तो इनका जेठलानी तो आते नहीं, जेठलानी साहब तो उसने इतने पैसे लेते तो इसको इतना आधा पैसा लेकर कर दो. But you won't believe it that I did not chase money then. If I wanted, I could have taken these matters, but I just thought I'll just stop everything. So basically the idea of telling you all this, and in fact, that's the starter thing, because it was very sentimental for me. Because this is one case where I just simply had to leave it at the end. My second cases were with NDPS, narcotics, drugs. Of course, then I was very careful. If the person is really innocent, then I would help him. If I know that this person is being caught every time the file goes, of course, then let him go to hell. I was least bothered. Anyway, the idea of telling you all this is that money is not the criteria in this field, especially because this is basically a public service. Don't forget that this lawyers का मतलब नहीं है तुमने एक murder को पकड़ा and कर दे. All right, if the right to defend everyone, the right is now. Of course, that question is always will come crop up in you as a budding lawyer. कि भैया जब मैंने law degree की है, जब मेरे पास then why should I do something for my bread and butter? And if there is a person who he's a murderer. Now the question, if he comes to you, all right, now let us does he need any protection? So in that condition, you have to defend him as far as trial is concerned, but defend him in a way where the legally it permits you. All right. So that is the criteria. Anyway, we are going slightly off topic. I'll not. So now coming back to the topic. So in like today's discussion, basically what I'm going to tell you about the digital revolution. Anyway, come back. So this is all the criminal background which I've been. We have exposure. We have very limited time, and today being a Friday, in fact Friday, Wednesday are heavy days of Supreme Court because all this breakfast, and you have to have something to, and you can't have like you are such a vicinity that you don't have access to the facility of canteen. So you basically order for Zomato, or if you are taking a cab, or if you are taking a Uber. So in such situation, you have to again press these buttons and ask for the make a suggestion, make a demand for the taxi. So tell me one thing. So once you click on the button, what happens? Have you ever thought of it? Once you click on this button of Zomato, Uber, or any of these apps, even asking for a loan, go to the bank. I'll come to that banking later. What happens? Basically, you are accepting something which they are offering you. So, in Indian Contract Act, so there is invitation to offer, there is offer, and there is acceptance, and there is consideration. So, once you press this app and accept something, so then that is nothing but accepting the offer which leads, and that the other person, he also accepts it, and it's a contract. So contract is formed. So if you break this contract, then it's a violation of the contract as per the Digital Act. Alright, this broadly I'm explaining to you so that you can understand the basics of this. Now, so there is another section, section 10A of IDEA. Now this act came in 2023. So prior to this, what was this? The section 10A, basically I'm just telling you the step-by-step reason why we had this, all of a sudden the legislature said, no, we have to have the Digital Act of 2023. So this section 10A was initially, as per this Information Technology Act of 2000, this was what is there. So the government, the legislature had in mind that there is bound to be any kind of clashes in this concern. So section 10 basically is the validity of contract formed through electronic means. I'll just read it quickly for you, and then I'll just explain it to you. It says, where in a contract formation, the communication of proposal, one who is proposing, the acceptance of the proposal and the revocation of proposal and acceptance as the case may be are expressed in electronic form. I'll repeat again, electronic form, again the button thing. Or by means of electronic record, such contracts shall not be deemed to be unenforceable solely on the ground that such electronic forms or means are used for that purpose. Alright, section 10A of IT Act. You have to just bury it in your brain because this is going to be the basics of everything. So take A basically is the electronic form. So I'll just come to how we came to electronic form because initially prior to all this electronic data we have the contract act. So contract act में क्या आता था? Offer, acceptance, consideration, and that leads to a valid contract. So if you revoke it, so it's illegal and void. So this was basically the second. Which was the second? The thing that. So this was the basic why we had this thing. So now I'll give you another example. Once you're purchasing, suppose you're purchasing something on phone. Now keeping this in mind, alright. So now you're purchasing something on phone, and when you see a phone on the app, so app you see that there are a lot of phones, so you choose this one, that one, whatever the brand. So once you see the phone listed on Amazon and the listing is not that listing is there, he just put it on the Amazon. So it says there, the phone is there. So that is not yet an offer, but it is basically an invitation to offer. So please keep in mind the minute distinction between offer and invitation to offer. So Amazon is basically inviting you to make an offer. So once you click on the saying that okay you accept it, so the Amazon app will take you to the cart. वो cart में चला जाता है, and that is the payment for you to make offer to purchase. Then that is time he says, all right, now you have accepted, now you can make the payment, and the Amazon he confirms it on your email. You get an email saying that look, after I have received this so and so, so I have accepted it. So this is there, and I'm going to send it to you. So then thereafter he asks you to make payment. Now how do you make this payment? You will not go because everything is online. So that payment is being done through digitally. So how digital is it? Basically it's electronic form that you are transferring that amount to that Amazon, and that is how the Amazon, once the payment is made, offer is accepted, that leads to binding contract. Basically that is now you have to buy that. So you can't now after making the payment say I want to get out of the contract. So that is imperativeness in law. So that is what the Digital Act also has, it makes it basically a legal binding contract. So now I'll just talk to you about the smart consent and mechanism. This is a very short, you must know. So as we delve deeper into the evolving landscape of digital contract, we now come to perhaps one of the most fundamental concept of modern legal practice, that is consent. So now what is consent? The traditional framework of contract act, consent has always been the beating heart of sustaining the validity of agreement. It is voluntary, unequivocal agreement of all the parties to be bound by the terms set forth. Without there, it is no contract. But in the age of digital interaction, how we ensure that consent is not given but is a valid form, that is to be traceable. So now, this kind of consent. So initially, what again I go back to the Indian Contract Act. Again, Indian Contract Act says offering acceptance to consent to section. So now the Indian Contract Act simply had initially what is that I'm going back because this is how the historical background, how we had to dig out from all this because of the digital revolution. So Indian Contract Act already had this consent term that consent should be free, it should be unequivocal, and it should be by a person who is capable of being, has the capacity to contract. So capacity to contract means it has to be a certain age, about the age of 18 years, that you should be competent to give the consent. So basically minor's consent is no consent. So in this digital form, we have this thing called smart contract. Smart consent. So the consent was already there. So now once we jump into the digital platform, we call it a smart consent. So smart consent refers to the process of capturing and recording consent electronically in a manner that is not only verifiable but also traceable. It's an increasing digital world that needs such mechanism as virtually protecting areas of privacy and data protection. So in everyday digital inaction, like I gave example as Zomato, and then of course Paytm. Now another app which way you have to make the payment once we are which is digitally sound and digital valid is the Paytm. Of course Paytm, I'm sure when you go to a shop, you want to buy something. Again, once you make the Paytm, again this is kind of a smart consent, digital consent. Once you make the payment, so this also falls into the terms of smart consent. So that now see, to be consent, to ensure as far as digital also is concerned, there are certain criteria and ingredients which are necessary. For example, first the consent should be free, that you should not be caught, basically no one should pressurize you. Consent, in other words, no one should have put a gun point at you, okay now you sign it. And it should be specific, it should be informed, you must know what you are consenting to, it should be irrevocable. You should have the ability to withdraw your consent. For example, you are just about to make the payment and you think, so you can immediately withdraw it. So this brings us to the Digital Personal Data Protection Act 2023, a landmark piece of legislation in India that takes significant strides in safeguarding the right of individuals in digital space. Under this act, the concept of consent is not just a formally but a critical legal binding process. The companies can no longer hide behind the lengthy terms and conditions and buried 20-page legislation. Consent under this act, and the digital contract, basically I'll just be very short because it's called DPDP. DPDP is what we say it in short form. The DPDP Act must be clear, transparent and easily understandable. So, now if we look into the further, we see that a growing trend towards the more dynamic and user-friendly consent mechanism. For example, we have the consent dashboard. These tools allow the individual to view, manage and modify their consent performance in real time, whether it is managing with app access to location or viewing what the data platform has collected from you. Consent dashboard empowers user to take control. So basically what this is trying to say is that this control with you. So basically with your own mind you are giving your consent. So blockchain based consent record is there, and real time permission management, these all elaborate. I'll not be very elaborate in that, but basically in conclusion, what is basically I'll just conclude by saying that the smart consent represents the future of legal agreement in a digital world. It is a bridge that connects up right to pricing with the need for business of innovative provide services. However, the onus is on the legal profession and the educators to ensure that the shift is not only technologically sound but also rooted to the fundamental principle of justice, harmony and individual right. So basically now coming to that back to what is the salient features of the act. So basically the intent of the DPDP Act was the digital protection law was to enact it was provided for processing of digital personal data in a manner that recognizes both the right of an individual. What is the protection of data meaning? So now at this stage the act is informed. So what basically is data protection? So protection of personal privacy from unwanted invasion as a result of misuse or abuse of information which is stored or retrieved in an informative system in which computer is involved. The data protection is the legal protection of individuals with regard to processing of information relating to them. So data protection rules and triggers the right to personal data. Now we have a thing like data signature, digital signature. So like if you are filing your income tax returns or like at many times now what has happened that even in Supreme Court we are doing many online filing. In the High Court we have this division of online filing. We are doing IPR matters where these people they have to file, and ultimately in the end in all these files, because Supreme Court, after the COVID, Supreme Court made it mandatory to do e-filing. Even the High Court made it mandatory because when the courts were closed during COVID, it became mandatory that everyone has to e-file. Now, after the e-file, to authenticate the documents, there was something called the digital signature. So this authenticity and the validity of digital signature came after COVID in 2019, where we could sit at our home, sit in our office and do online filing by doing digital signature. So these digital signatures, you have to, it says, it's electronic signature, and any electronic method, type a name, and then you click I agree, or use the metric at instant and say that I hereby verify that the contents of this petition are true and best of the correct of moral knowledge, and then the lawyers, they digital sign it. Or in case of IPR, for these people, so I need so they check, so I just check that ultimately for filing these, my colleagues, they just sign on my behalf, that so the law firm is, and they agree basically. So once you agree, so digital signature, so that becomes again a legal binding thing. In case anything goes wrong, like I can't tomorrow then deny and go back and say, look, I did not sign it, my junior signed it, what is it, not myself. Any lame excuses will not be accepted. This also implies in income tax also. Once you filing a return, once you grow up, you find your CA will ask you about the digital signature karna. So then he signs it for you. So tomorrow, when something crops up, some problem arises, you can't say, look, my CA signed it and digital signature, I have to sign it. So that can't be taken place. So again, the protection this act clearly says that this is once you have done a simple e-signature and secure digital signature, it becomes the evidentiary value. So it is in all assets. Once you've signed it, and for example, in case of income tax regulatory authority, they find that you have hidden some information, and it can be used as an evidentiary to prove any cases against you. Now, as far as IPR is concerned, the intellectual property and digital representation. So, intellectual property, we have trademark, patent, copyright, the Designs Act, and geographical. So, this IPR office, you must have heard this in Dwarka, so that is the head office there. So, for digital representation of work, that is the text, image, software, music, for raising copyright license issue, unauthorized production or distribution digital form constitutes infringement. So any kind of infringement, so it has to be met with a firm hand. So the digital right management and the technology protection measures are legally recognized and framework. So basically the idea to tell you is that everything is it's legally, it has a legal binding and it's of effect. So tomorrow when you are digitally signing something, so make sure that you are reading whatever you are reading, it's in terms of your and it suits you as per your requirement is concerned. Now coming to chapter 4. Now again chapter 4 talks about the information is most valuable resource of the digital economy. The information technology encapsulates system for processing, storing, retrieving and communicating information, while software technology provides the operational backbone of IT through program and applicability. The law plays a vital role in regulating ownership, access, use and protecting of information technology ecosystem. So as far as now IPR is concerned, software protection is concerned, we have the Copyright Act, again the protects original right, the patent, of course, in the as far as patent, once you go higher up in your semesters, you read this IPR. So just broadly I'll tell you where the copyright law protects the original literary work, which includes computer programs and software codes. So copyright is basically that if you're publishing any books or something, so you go to the copyright office and you get it copyright. If you read any books, you must have read many of these Arthur Sidney Sheldon, any foreign books or foreign author's book. So you will see right in the end is C in a circle written. So that means it's copyright. So once this is copyright, so it means that you can't make a duplication of this, and in case you do duplication, then that is infringement. So now that is in the proper book form. So now what has happened now, all these books and these the copyright of the authors are coming out, they are publishing their stories and their work through digitally. So you just download the whatever you want to know and you just reproduce and read it. So that can also be, now this act basically gives protection to them also. So that is how the copyright is there. Now similarly there is the patent. Now patent again there is a software related issue. Now once the software related inventions are there, so they also become patentable and get protection under this act. So trade secrets, the source code, we have the confidential data, so all that comes under the protection of the present act. So now we just quickly chapter 5. Now chapter again 5 talks about the personal data, the data processes and internet technology. So we have what is happening in petition all. So we will not go there. So we just basically confine to the Indian. So as far as India and the Indian total jurisdiction is concerned, Section 3 is one of the important chapters. Chapter 6, which says that the Section 3 is a digital person that the acts dealing with the scope of the act. The Act was enacted on paper to read to provide for processing of digital personal data in a manner that recognizes both the right of an individual to protect their personal data, right of the individual, and number 2 is the need to process such personal data for lawful purposes and for matters connected thereto, incidental thereto. The purpose for enacting is to protect the digital personal data and to ensure that the processing of such data is done for a lawful purpose. So now we have, I'll just like to tell now how much is the jurisdiction. So now we have talked about this act, like it's confined, it says applicable to the whole of India. But section 75 gives extra territorial scope. So now this any offence or contravention committed outside India is covered and it involves a computer system or network located in India and it ensures protection against cross-border cybercrime and misuse of Indian digital infrastructure. So this provision was added to give it extra total jurisdiction. In fact, this is the only act because what has happened, like I give you one small example of Hawala transaction, what happens, the money goes out. Hawala, what happens, the country's economy is affected. Hawala, all the money which is illegally collected or is being used by abuse of to commit illegal crimes, now that goes out of the country. So to ensure that we get information from outside the country, this 75 Act was incorporated. So this was purposely done by the legislature to ensure that we have full right to know what is happening and where the money is going and why it is going. So now, so this mentions now judiciary obligation. Of course, we have the data fiduciary, not. Now, I'll just go quickly to section 39. Now, this 39 is basically very important. It is under section, it says the power to call for information and issue direction. So this section, the provision codified section 39 to 45 of the Act are the legislative tools that ensure the Act's smooth functioning and then in practice. Section 39 gives the power to call for information and issue direction. 39 says the central government, what I was just repeating, I'll just leave the provision in this regard. The central government may call for information from the DPDI board for any data fiduciary for purpose of enforcement of effective implementation of the Act, issue direction to the board which are binding on matter of policy. The purpose and implication was to ensure the government oversight over the functioning of the DPDI board without interfering in educational independency, enables the government to respond to national security and public interest concerning the data ecosystem. So this 39 to 41 gives the powers to the government, to the central government, to ask for any information which are against the country and against the public interest. So this was purposely kept to ensure that we meet the requirement in this regard. So now, without going any further, as the Act goes on and on, so I have the endless picture in front of me. So I'll just quickly, this is very important, I'd like to just discuss some case laws in this regard. So one is Justice Chandrachud, who was the previous Chief Justice of India. He talked about the right of the children in this regard. So I'll just briefly tell you what happened in this regard. So this again pertains to data protection and data information. So what happened in FI was registered by the by the crime for downloading and storing child pornographic material. The following answer confirms that 2 videos of his mobile and admitted habitually viewing them. A charge sheet was filed against under section 15 of POSCO. Now POSCO is one of the acts which is against the child abuse, like any child who is abused by anybody. So POSCO is this thing, and POSCO is non-bailable and you can't get out of it. You have to be in jail and no court to give you bail if you are held liable charge sheet under POSCO. Law students navigating the textual and case law and see yourself as the future architect of India's digital legal framework, professional who will shape how the trust, accountability and fairness to operate the online world. And every time you casually click on I agree, pursue and imagine how that experience might be improved for millions of users. Would the consent process be clearer? Would the term be fairer? Would access be immediate and faster? They are not abstract questions, they are opportunities waiting for innovation lawyers to solve. Now, to prepare for this role, immerse yourself in the speed, follow technology, law cases and develop in the court of tribunal, read privacy policy not just as a consumer but as future drafters. Take internship with technology companies, law firms, regulatory bodies. Consider pursuing certificate in cyber law, data protection, emerging fields like AI and blockchain governance. The earlier you expose yourself to this ecosystem, the more valuable future readiness you will become. And of course, I will close my thought by saying that digital economy is not distant horizon. It is here and it is now, and it requires lawyers who are willing to adapt, innovate and lead. My invitation to you is simple: step into this space with curiosity, with vigor, with wisdom, with vision, because the future of digital law in India will not be written by technology alone, it will be written by lawyers like you. With that, I just conclude my session, and thank you for all of you for giving your attentive time and your audience. It is definitely fantastic, interesting and coming here. Again, it is my thanks to the faculty members and calling me here. And of course, I keep coming, and of course, I presume this was not very boring for you and you enjoyed the topic of this. I could see that people in the end were very curious that they were very curious looking into this side also. So you have any question, you please let me know. Then I can.
They do have some questions.
Good morning, sir. My name is Mohammed Anas. Sir, Mohammed Anas. Sir, I have this question, like we are in the era of artificial intelligence, right? And many of the sectors has already...
So there are 2 fields, keep in mind. So one is the litigation oil of what we are, and one is the corporate. Of course, we also do, we have a law firm, and as a law firm we have corporate team also doing corporate work. But I